Recording? Okay. Welcome, everyone, to the September 5th, 2023 meeting of the San Francisco Elections Commission, Fair, Independent, and Effective Redistricting for Community Engagement, or FIERCE Committee meeting. I am the chair, Cynthia Dye. The time is now 6:06, and I call the meeting to order. Before we proceed further, I want to briefly explain some procedures for participating in today's meeting. The minutes of this meeting will reflect that this meeting is being held in person at City Hall, room 416, 1 Dr. Carlton B. Goodlett Place, San Francisco, California, 94102, and remotely via WebEx. As authorized by the Elections Commission May 17, 2023 vote, members of the public may attend the meeting to observe and provide public comment either at the physical meeting location or remotely. Details and instructions for participating remotely are listed on the Commission's website and on today's meeting agenda. Public comment will be available on each item on this agenda. Each member of the public will be allowed 3 minutes to speak, 6 minutes if you are on the line with an interpreter. When providing public comment, you are encouraged to state your name clearly. Once your 3 minutes have expired, staff will thank you and you will be muted. Please direct any of your comments to the full body and refrain from directing them at individual commissioners while providing public comment. While providing public comment remotely, please ensure you are in a quiet location. When joining by phone, you will hear a beep when you are connected to the meeting. You will automatically be muted and in listening mode only. To make public comment, dial *3 to raise your hand when your item of interest comes up. You will be added to the public comment line. You will hear, "You have raised your hand to ask a question. Please wait until the host calls on you." The line will be silent as you wait your turn to speak. If at any time you change your mind and wish to withdraw yourself from the public comment line, press *3 again. You will hear the system say, "You have lowered your hand." When joining by WebEx or a web browser, make sure the participant side panel is showing by clicking on the participant's icon. At the bottom of the list of attendees is a small button or icon that looks like a hand. Press the hand icon to raise your hand. You will be unmuted when it is time for you to comment. When you are done with your comment, click the hand icon again to lower your hand. In addition to participating in real time, interested persons are encouraged to participate in this meeting by submitting public comment in writing by 12 p.m. on the day of the meeting to elections.commission@sfgov.org. It will be shared with the Commission after this meeting has concluded and will be included as part of the official meeting file. Thank you. All right, we're going to do roll call. Commissioners, please verbally state your presence at today's meeting after your name is called. I am Chair Dye, and I am present. Commissioner LaVolsi?
Present.
Commissioner Parker?
Present.
With 3 members present and accounted for, this FIERCE committee meeting, we are ready to proceed. And with that, let us go to the land acknowledgement, if you will, Commissioner LaVolsi.
Yes, thank you, Chair Dye. The San Francisco Elections Commission acknowledges that we are on the unceded ancestral homeland of the Ramaytush Ohlone, who are the original inhabitants of inhabitants of the San Francisco Peninsula. As the indigenous stewards of this land and in accordance with their traditions, the Ramaytush Ohlone have never ceded, lost, nor forgotten their responsibilities as caretakers of this place, as well as for all peoples who reside in their traditional territories. As guests, we recognize that we benefit from living and working on their traditional homeland. We wish to pay our respects by acknowledging the ancestors and relatives of the Ramaytush community and affirming their sovereign rights as First People.
Thank you, Commissioner LaVolsi. All right, we are going to move on to item number 2, general public comment. Public comment on any issue within FIERCE's general jurisdiction that is not covered by another item on this agenda. Hello?
Oh, hold on. Let me get.
Yeah, pause. Thank you, Commissioner Parker.
All set here? No. Yeah. Perfect. Good evening, Alan Baradell. This weekend, there was an article printed in this Standard by Annie Gow, and it referenced this last meeting here. And I'll just read a little briefly. She said that the Controller's Office and the Department of Elections were both mentioned as possible selection and vetting authorities. But one commissioner added that the Elections Commission then ruled itself out because of a lack, as she puts it, Annie Gow in the Standards, a lack of public confidence. And that's the reason why this commission decided to rule out the possibility of having the Elections Commission as a vetting authority or a selection authority. And I thought to myself, what could have led to such a lack of confidence in this commission and in the Department of Elections that could result in this commission believing that it didn't have the confidence of the public? Can you imagine a department of the city not having enough confidence in the public to be politically neutral? It should be the Elections Commission for sure. But then I went back to April 6th, and it was 2022, April 6th. And there was a commissioner at the time, I don't know who it was, but I was listening to the tape, and it was the meeting where you all were considering whether to bring in the redistricting task force members to a commission meeting. The first question, what is our, and I'm quoting him directly, by the way, what is our authority for taking this action? Number two, is there a failure of due process here? If so, that would require a legal remedy. But I suppose it could also be a political remedy if it's a political problem. If so, and if it is a failure of due process, that would be a legal remedy. And any political remedy this wouldn't be the place to handle a political remedy, okay, is what he said on April 6th of 22. Number three, if this commission does choose to take the action of replacement, what will the process be that's required? And he went into some comment after that to say, is this commission doing the right thing by substituting our judgment for their judgment? Do we replace them in a way that's legitimate? And does that make things worse? Okay, this is what this commissioner said. Number four, the charter says the deadline is April 15th, just because there's no civil or criminal penalty imposed for not meeting that.
Thank you, Mr. Baradell, your time is up. Thank you for your comment.
Thank you.
Let's see if there are any commenters online.
I saw a hand raised. Jen.
Yes, you are muted.
Hey, good evening. Thanks for continuing this important process. Oh, sorry. So I'm Jen Say with the League of Women Voters San Francisco. I want to say thanks for continuing this important process to support much needed redistricting reform. San Franciscans deserve fair elections, and the foundation of fair elections is an independent redistricting process that prioritizes the needs of our communities, not the needs of elected officials. The League looks forward to hearing your discussion tonight and is available if you need any assistance finding information on independent redistricting best practices. Thank you.
Thank you, Ms. Singh. All right. Seeing no more hands, I'm going to move on to item 3. Actually, we're going to skip past item 3 because it was, we're going to go ahead and treat this as a continuation of the last meeting and do one set of minutes, which of course means I'm volunteering for that. So you guys are off the hook. Moving on to the main event. Welcome back, everyone, from what I hope was a somewhat restful holiday weekend. I know this has been, it's a difficult day for all three of us, and I'm impressed that we all made it right after a holiday weekend. So I want to thank you guys for agreeing to that. As I mentioned, this meeting is a continuation of the August 24th meeting agenda, where we didn't quite finish discussing the key reforms under consideration to improve our local redistricting process. We got about halfway through, and we intend to power through the rest of it tonight to distinguish between the ones which we largely agree on and those that might require more discussion. Members of the public can refer to the final attachment for this agenda item. We will also be sharing this deck on WebEx for those to see. But before we launch into that, I did want to draw your attention to Sunday's New York Times article on the gerrymandering scandal in Los Angeles. Our guest speaker from a couple meetings ago, Dr. Sarah Sadwani, was quoted in it. And, for me, I think it really highlighted the problems with political appointees where city council members were appointing bigger guns, or reappointing bigger guns to square off against other appointees, only to entirely ignore community input in the end and the advisory commission's recommendations. I also wanted to update everyone on the status of pending legislation. AB 1248 and AB 764, the update to the Fair Maps Act. Both have passed out of Senate committees and are now on the Senate floor. I will admit, I only was able to kind of glance at it before today's meeting. They got out of committee on September 1st, so I didn't have a lot of time to look at it. But there is one significant amendment that I wanted to highlight in AB 1248. Which I thought I wanted to make sure everyone on the committee was aware of. And that is with regard to the selection body. So it looks like it has been amended to allow for more options. So remember before there was like a precedence of selection bodies that we would have to consider. And the city attorney had concluded that for us, it would be the Ethics Commission. Now it's multiple choice. So now we can choose from any one of those, and they've added more options. So anyone can go and just Google AB 1248, and you will be able to find the leginfo.legislature.ca.gov, and you can look it up. So let me see if I can just find that section real quick. The new option they've also added is a panel consisting of one representative from three of the following: the Ethics Commission, a committee or commission with a holistic view of the local jurisdiction's governance process, the controller, city attorney, city clerk, or city treasurers, if these offices are not elective offices, a retired judge appointed by the chief judge of the Superior Court of the county, and the civil grand jury of the county. So that's a new option. So I think that's really interesting. I think we still agree we don't know what the right answer is for San Francisco by ourselves, but that's very interesting. And so it does look like it's going through very thoughtful consideration by our state senators. And there were some other additional amendments, mostly from what I could tell, making sure that candidates for the California Citizens Redistricting Commission that are not selected for that commission are forwarded to local jurisdictions as long as they give their permission. So there's some clarification around that. On 764, there were also some revisions that were minor. I don't think most of them apply to us, but that was the big one. So I just wanted to share that with you guys.
Thank you.
I don't know if my fellow commissioners had any thoughts on the article or any other updates before we launch into the slides.
No.
Nope. All right.
Thank you for sharing them.
Commissioner Parker, It is off to the races.
Before we talked at the end of our last meeting, if we maybe wanted to allow a little public comment on the first three items. Did you want to still do that in case people had kind of afterthoughts after letting it sink in? We had talked about that in our last meeting.
Yeah, and we did not receive any written public comments. So we could do, let's see, so we did, do you want to just recap where we got to? And then we,
And then allow a little comment and then get on?
yeah.
Sure, I could do that. Hold on one sec. I'll just share my screen real quick and guide
And I
everybody
think we'll want the
along.
clerk's PC, right?
Yes, please. There you go. I wonder, is there any way to make that fill the screen bigger, or do you think that's kind of the best we can do? Is there any way to make that the screen fill, the slide fill the screen more, or do you think that's the best we can do? That's a good question. 'Cause I know it's hard to read if you're looking at a screen.
No. I think view full screen view.
There, well, that's better, right? A little better. Okay, so very quick recap of what we did last time. This is a, oh, there you go. Well, yeah,
Yeah.
thank you. This was a deck that would allow us to guide us through a conversation discussing the various components of redistricting form that have been discussed in kind of reform initiatives, and help us consider all the questions that San Francisco could be asking, should be asking, as it considers making changes to the existing processes here, some of which would require a change to the city's charter. And so last time we just did a quick review of some of the context. This is why we are considering the topic, which is that San Francisco was a pioneer in independent redistricting and has now fallen behind in best practices. And everybody we have spoken with who was on the last redistricting commission, including that last redistricting task force here in San Francisco, agrees that some improvements should be made. And we on this committee are part of the Elections Commission, and we are responsible for ensuring free, fair, and functional elections, which does require fair districts. So that's why this is on our plate. And then I did a quick walkthrough of existing state and local legislation, the city charter, the Fair Maps Act, which doesn't apply to charter cities, but it still is a pretty relevant document to refer to, and also talked about some history and some previous presentations we've had at the commission, and then talked a little bit about the state legislation that Commissioner Dye just referred to, AB 1248 and AB 764. And then why we are considering this now is there's a recent range of experiences with the public that they have had that allows for more meaningful community engagement before it's too far out of people's minds, to provide some input for potential reform, and also because it takes time to run a fair and democratic process. We want to make sure there's enough time to prepare a new independent redistricting body and support city agencies to implement a fair process before the next census. So the components that we reviewed, I'm not going to go into detail about any of the discussion, just to tell you which components we did review last time. These were the 7 that we are going to review in total. We went through the first 3. So those are the composition of the body itself, the selection and removal process, and the commissioner qualifications and restrictions. And just to note, well, actually, I'll pause here for 1 second. You'll occasionally see some acronyms throughout these slides. RDTF means Redistricting Task Force. IRC is Independent Redistricting Commission, which is what this type of a body is usually referred to in any kind of state level legislation, or all the reports that you'll read, they refer to them as IRCs. The Board of Supervisors is BOS, CCRC is the California Citizens Redistricting Commission, and FMA is the Fair Maps Act. So we went through the composition, and you'll see that each of these slides, there's a general structure to them where there's a key question, some kind of a quote from a report, or a key note to be thinking about. And then on the right, there's a list of questions to consider that led a lot of the conversation that we had on each of these. And then there was always a chart that happened on the second slide for each of the components that shows what existing San Francisco law says, pending California legislation, that AB 1248 and 764, the Fair Maps Act, and then a recent report that talks about what's been a result of the Fair Maps Act as it has been implemented in various jurisdictions across the state. And the next column is recommendations from the most recent San Francisco Redistricting Task Force. And then the last column is the California Redistricting Commission. And the next one about selection and removal process had 4 subsections about outreach and recruitment, qualifications and restrictions, vetting and selection and removal. And then just scrolling through those quickly. Thank you for your patience. And then we arrive at the 4th, which we will pause for a minute and take any comment on what we discussed last time.
Okay, Alan Buradell. So I hadn't thought that I would be commenting on this. I'm glad to be up here, though. First of all, the New York Times, I'm going to respond to Chair. This quote and information that they provided about Sedwani and what they're going through down in LA, you continually try to tie what's happening down there, this board does, this commission, to what's happening here, and it's totally different. They have 20-some council members down there. They each appoint a advisory person, and you're right, they kept letting people go to bring in stronger advisors to then only ignore their advice when they closed the door and drew the maps on their own. They've got a terrible system down there. It's got to change. It's totally unfair to we citizens who pass Prop L to have these 3 bodies do the selecting and vetting of candidates. We do it totally different than LA, and it's unfair to say that we do it in a similar way. Second thing, 1248, or best practices. We hear a lot about that today and throughout this whole process. Best practices according to who? It's a political matter we're talking about here. When we're talking about redistricting, there is no best practice with this. It's a political matter. It's a matter of political outlook on what a best practice is, no matter how much you try to characterize it as a cut and dry clinical matter of studies and data. It's just not that. And then requires fair districts. Your mission requires fair districts. The mission of this commission, which is to oversee the Department of Elections, you require fair districts in order to carry out your mission. It's not, that is just not right. You don't require that to carry out fair elections. Elections are an event that happen, and you oversee the process of that event happening. Fair representation is up to the people to decide whether or not they're fairly represented, and their recourse is to go to their Board of Supervisors and give them the boot or give them the vote. But you are losing your credibility here by taking on this matter, and that goes to the heart of why you can't even select yourself or nominate yourself to be a vetting or selecting authority. This is why you're taking on for the past year and a half this political matter. It is political, and you should let it go. And that's all I have to say about this item.
Thank you, Mr. Buradell.
Thank you.
All right, let's see if there's any public comment online. Let me unmute. Okay, you are muted. Ms. Say, do you want to make a public
Oh,
comment?
sorry. I forgot to lower my hand.
No worries. Okay. Seeing no more public comment, let us go on with our review.
Okay, so we are at the fourth of our 7 components. This one is about the redistricting line drawing criteria. Key question here is what criteria will reduce political influence, keep communities of interest whole, and increase transparency? The yellow box to the side here is just sharing the definition of community of interest from the California State Constitution for reference. The Constitution defines a community of interest as a contiguous population which shares common social and economic interests that should be included within a single district for purposes of its effective and fair representation. Some of the key questions that I've suggested could be considered here are, should San Francisco deviate from the Fair Maps Act criteria to accommodate unique characteristics? And if so, how? Some examples might be cultural districts, communities of interest definition, the 5% population equality between districts. Just as a reminder, we are not required to fall under the Fair Maps Act criteria, but it is a suggestion we could look to, and that's why I've suggested this question. Should San Francisco rank criteria in alignment with the Fair Maps Act and the California Citizens Redistricting Commission requirements to prevent cherry picking to justify preferences, of individual commissioners, et cetera? Which criteria can be required to reduce political influence? For example, some of the types that you'll see are no incumbency protection. So meaning that if you have an existing elected official in an area, you don't protect where they lived in order to let them stay in that district where they were elected into. You don't consider where they live at all. Consideration of electeds' political affiliation. For instance, if they are one political party and the rest of the district is a different or the same, and just trying to consider that when drawing the lines. And then the last question here is what should be included in final reports of the redistricting task force to increase transparency and accountability regarding adopted lines? For our chart here, so current San Francisco law, the line drawing criteria is not ranked. It is just a list of criteria. We're asked to substantially comply with the 1-person, 1-vote rule. Districts should be contiguous, compact, and recognize neighborhoods. Population variations are limited to 1% unless variations are necessary. And to expand a little bit on that is if they are necessary to prevent dividing or diluting the voting power of minorities and or to keep recognized neighborhoods intact. Must consider communities of interest, and there is no prohibition on incumbency protection. Let's see. And then for the pending California legislation, AB 1248 relies on the Fair Maps Act. It does not define any new criteria. AB 764 prohibits incumbency protection and adds some clarity regarding communities of interest. The Fair Maps Act says that where practicable, districts should be geographically contiguous, keep communities of interest whole, minimize division. They should be easily identifiable and understandable by the residents, and bounded by natural or artificial barriers, encourage geographical compactness, and the districts must be substantially equal. And then the Promise of Fair Maps report made recommendations to prohibit incumbency protection and discrimination, both. Ranked criteria must be followed to the maximum extent possible. Unranked criteria cannot be prioritized over ranked. So if there are 2 sets of criteria, you can't prioritize unranked criteria over the ranked criteria. And then they must also they're suggesting that The districts also do a Gingell's prong 1 analysis and publish a summary of racially polarized voting analysis. Now, just pause for a second. When I read that, I was like, what the heck is a Gingell's prong 1 analysis? So I did a little bit of research for you all, which I will share. Section 2 of the Voting Rights Act prohibits the implementation of voting districts as well as other laws and practices that result in less opportunity for minorities to participate in the political process and to elect representatives of their choice. For example, Section 2 prohibits redistricting plans that divide a minority group neighborhood into separate voting districts and thus weaken the group's political power to elect a candidate who addresses their concerns. This is sometimes called cracking. If you've seen that in various elections, research or gerrymandering articles, you'll see that term. Section 2 also prohibits discriminatory electoral schemes, such as at-large elections that tend to dilute the voting strength of minority groups. Section 2 prohibits such practices and devices because all citizens are entitled to realize the full power of their vote and have an effective voice in the political process. So there was a case called Thornburg versus Gingell's. And the Supreme Court in this case established 3 criteria for proving racial vote dilution under the Voting Rights Act, so therefore violating Section 2. And those 3 prongs are: a minority group must demonstrate it is large and compact enough to constitute a majority in a single member district. A minority group must demonstrate it is politically cohesive. And a minority group must demonstrate the majority group votes sufficiently as a group to defeat the minority group's preferred candidate. Okay, so that's what those are. Hopefully that clarifies a little bit. You can do additional research if that's helpful. And then redistricting, the recent redistricting task force here in San Francisco did not have recommendations as a body around the line drawing criteria. And then the California Commission has a priority order. Population should be nearly equal for Congress and reasonably equal for state seats, should comply with the Voting Rights Act in contiguity, respect integrity of neighborhoods, compactness, and when possible, nest 2 assembly districts within 1 Senate district. And there should be no protection or discrimination against incumbent, candidate, or party. And that is my summary for redistricting line drawing criteria.
Very impressive, Commissioner Parker. It's actually jingles, and
Oh,
yeah, and we on the California Citizens Redistricting Commission had to
Right.
learn all about racially polarized voting and all of that. But basically, it's to prevent minority vote dilution in summary. And the jingles tests are intended to provide some guidelines around that. And one of the challenges we had in drawing districts that were compliant with Section 2 of the Voting Rights Act in Los Angeles in particular is the fact that people are pretty spread out and mixed. And so one of the comments I made when we were looking at census data, and they had a different color for each racial group, is that it looked like a Jackson Pollock painting. And that's one of the challenges. If they're not geographically compact enough, then it's hard to perform those analyses. But generally, that's not the case. Generally, there are distinctive neighborhoods and communities where people live together, and then you have to consider them for the Voting Rights Act. So that's just a little background. The way that I explain the rank criteria for the CRC is that we have 6 rank criteria. The first 2 are federal law. So by definition, all maps must comply with federal law. So that's population equality. And for Congress, it has to be plus or minus 1 person. And then there's a lot of latitude for state and local jurisdictions because we're much smaller generally, the jurisdictions. And so one of the questions I had asked, because the San Francisco City Charter actually has very few criteria. It has 2, basically. One was on the population and one was on community input in neighborhoods. is that there was actually a tight population deviation, as Commissioner Parker pointed out, 1%, with the ability to go to 5%. And actually, case law allows much greater latitude. 10%, sometimes even larger than 10%, have been allowed by courts for local and state jurisdictions, because when you start talking percentages and the absolute number of people is quite small,
Right.
it's, you get a bigger percentage, basically. The CRC chose to keep a pretty tight population deviation, but that's because our state Senate districts are like 1 million people. So you don't want to deviate by 10%. So that was one question I had, because the current charter actually puts a tighter limit than case law. And the question is, should we? Because the whole reason for having that latitude is to, get around physical barriers, or if there's a neighborhood or a community you want to keep intact, then you have to go deviate a little bit to keep that community intact, and that gives you a little more latitude to do that. So the first two are federal law, and then there are state criteria that are ranked, which is the contiguity, the respect. It's not only for neighborhoods at the state level, it's respect for cities and counties. I call that kind of political geography. So, and on a local level, we're mostly looking at neighborhoods and communities. Compactness, and then the nesting doesn't apply to us. Obviously, that's only at the state level as well. And then there's one prohibition, which is not to consider candidates or elected officials where they live, the parties. So it's basically not consider them, don't discriminate, don't consider them, don't protect them. And obviously, that's normally what we see happen in these situations, because gerrymandering is generally about protecting elected officials or candidates' interests or parties' interests. And so that's a way to break it down. The Fair Maps Act was basically copied the criteria from the California Citizens Redistricting Commission. It adds some additional comments here, which I think makes sense, making it understandable so other people understand why the districts are drawn that way, that they're bounded by natural and artificial barriers. This was not explicitly called out in our state constitution, but it was something we absolutely considered. So, for example, we'd consider highways as an artificial barrier. A river or a mountain would be a natural barrier. We absolutely looked at topography, because people live in certain places and they don't live in other places. And so that changes like the density of the population. So that's just a little background on that. But yeah, the FMA pretty much mirrors the CCRC's criteria, with the addition with 764, which is intended to update the Fair Maps Act to explicitly prohibit, in the same way the state does, consideration of incumbents. Because obviously there was still some problems in this last cycle. So, any thoughts on this? I think I've shared my experience that the rank ordering really keeps you disciplined, because you have to check every district and check to make sure it complies in order. And I think I described, after our first draft maps, we were so exhausted and trying to meet this deadline that we did the nesting. We just told our consultants to put two together and, just nest them for us. And we found out we were violating the Voting Rights Act, because once you get a bigger area, you got to consider different communities, right? And so that is a very clear example of being a little cavalier going through the criteria. We ended up trying to just do the nesting. And we found out in the end, we were unable to nest perfectly or at all in several cases because of the Voting Rights Act. And so we had to go back to the drawing board and refigure that. We also found that we did our draft maps with a bigger population deviation, just to see what we could do. And then we tightened it for the final maps. And by doing that, that changed the maps as well. Because again, that comes first. So just to give you guys a flavor of the interaction. And I will say, we asked the two panels of redistricting task force members we had about rank criteria. And they were kind of challenged to imagine it because they didn't have to do it. But I think one of the criticisms of this last cycle was that people would cite all kinds of reasons for drawing districts the way they would. Like, I'm from this area and I want to keep, this neighborhood whole and what have you. And, the question is, okay, but what about another neighborhood that also wants to be whole? How do you break the trade-offs? And so there's still going to be trade-offs. There's no question. We did that all over the state. We had, for us, it was criterion number 4, where we had to balance city boundaries, county boundaries, neighborhood boundaries, and then community of interest boundaries. And they were all at the same level. So they're going to be trade-offs, but the clear thing is we didn't make that trade-off against contiguity or population deviation or Voting Rights Act issue because those were higher.
Right.
So we had to fix those problems first before we could make those kinds of trade-offs. And then we had to justify it in a final report and show that for every district we drew, that we complied with the rank criteria. And
That
so
sounds pretty.
that was the accountability mechanism.
No, that sounds really great. I mean, I do think we have to keep in mind that often when you look at things that have happened in other jurisdictions and in other maps or other redistricting, it's trying to dilute the vote of certain communities. So I think wherever we can make sure that's not happening, especially of a smaller community, that's a small minority in a city, in a district. I think that's where I would want to make sure that our recommendations are that the Board of Supervisors really make sure that we put things in place to protect particular communities that have traditionally been the target of diluting or dividing population. So for me, that would be one of the most important things, to make sure that recommendation is there.
And I also like that Commissioner Parker included the definition of a community of interest, because that's a challenge, because then anyone can define a community. In fact, we had people come and tell us that you should draw a district this way because I live here and I shop in that mall, and therefore I should be in the same district. So there were all kinds of interesting justifications for why this was a community of interest. And obviously, the commissioners would take certain ones with a grain of salt. And we asked people to provide evidence, like what makes this a community? What makes it a contiguous population that shares common social and economic interests?
Right.
And, is shopping at 2 malls, does that mean you should have the same elected representative? Right. So we had, we had people come from the League of Conservation Voters and explain why people living in a certain watershed were a community of interest. So they used environmental justifications. And we had people come and show their church and the community centers around it. Obviously, we had census data for particular populations, so we could see that. But people had to actually show us that there were common social and economic interests. They couldn't just state we're a community of interest and, because we all like the color blue, you should give us the same representative. But I mean, believe me, people tried all kinds of different justifications, but I think aligning with the state definition, I think is important so that we're
Mhm.
clear
Right.
what, constitutes a community of interest. So people, provide a historical references, and, economic data, uh, uh, to show why.
Mhm.
People looked at media markets, there were all kinds of things, but the point was to show those common social and economic and cultural ties in many cases.
Mhm.
Any thoughts?
Yeah. So I mean, I have a few, I'll just share a few different thoughts here. I think it is helpful to align with, a state constitutional definition and, things like that. I think we should, if we consider deviating from state law, we should ask ourselves why, because there could be a good reason. I think that's one of the questions, right? Is should we consider that? There should be a good reason to not do that. I think sometimes we suffer from thinking we're very, very special here. And we do have unique interests here for sure. So I just think we should just ask questions before we deviate, not just do it.
Yep.
And I think one of my main questions related to these criteria when I'm looking at, for instance, I'll move back to this, the chart slide here. The Fair Maps Act, which, as you said, sort of copied the California Redistricting Commission. And then there's these sort of recommendations that were made in the Promise Fair Maps that now 764 has included. My question is why shouldn't we follow those? Maybe not necessarily should we, or should we create something new? But I'd love to hear if there's a reason we shouldn't do that. If the public has reasons, a lot of this makes sense to me, given what the law is. So I'm curious about is there a reason why we shouldn't just follow the recommendations and what exists already in the Fair Maps Act? And the new recommendations or the additions to that through current legislation. And then the other comment I wanted to make was around the equal size of districts and the 1%, 5%, 10% as you were bringing up. If I recall correctly, and it's been now a couple of weeks since I read the redistricting task force report, and looked at the maps and the distance between those. I'm not sure if there were any at 1%. I think that we're all closer to 3, 4, right, in kind of the higher towards 5 as they were trying to draw those maps. And it seems reasonable to have the 1 to 5. 10 just feels a little big to me, that it leaves a little bit too much room to, I don't know. I mean, I think that, following these priorities of criteria and then having up to 5% seems to be reasonable. But again, I would really love to hear if there's a reason why it shouldn't be that. And 1%, that seems very, very difficult if you're asked to also be compact and contiguous and all of those kinds of things. That seems like a hard hurdle. But if you can do it, great, if you can meet all those criteria. So it just feels like as equal as possible. So that's the other thing that seems reasonable. And I wonder if there's any reason not to be capping it at the 5. And hold on, I think there was one more thing that I maybe wanted to. I guess the last thing was just around final reports. I do like the idea, but I also get like very nerdy about stuff like this. And I like the idea of and I'm sure that there are some task forces who do voluntarily, offer some of this. They're not required to, they do it. It's just a measure of transparency and building trust with the community. And I like the idea that final reports do include a rationale for here's why we made the choices we do, because not everybody can watch all of the meetings. Like that's a barrier for a lot of people. We have it's wonderful, the people who were able to make it, and it's not possible for everybody. And so I like the idea that there is something written that we can then go back to and refer to and understand better. So I like that for transparency. I like that for just wanting to understand better. So those are my three comments.
I'll comment on a few of them. So my thinking is, back to your point that we're not really that special, is why not comply with case law?
Right.
As opposed to artificially putting a cap. And the way that state law is that it allows up to that kind of deviation, but you have to justify it. Because at the end of the day, it's one person, one vote. So if you deviate significantly, it has to be something that will stand up in court, essentially. And it's also, as I understand, it's a maximum deviation. In other words, the maximum deviation from the smallest district to the largest district cannot exceed X. So people get confused. It's not plus or minus 10, in other words. And because case law allows that flexibility, it means like one could be -3 and the other one could be +7, in other words. So instead of bounding it plus or -5, which is the way the charter is written. So I think that my personal thought is that it makes more sense just to comply with case law, because that may change over time. And if for reasons, the justice system decides to make it tighter, then we would just naturally evolve with that, as opposed to having some absolute number that's stuck in our charter. So that was my thinking on, the case law question and not having our own definition there. In terms of, I completely agree with you on the final report. I have to tell you, it really kept us accountable. As one of the two commissioners who had to write most of that final report, we literally had to slog through every district and say, this was an agricultural district. This was, we had to describe what that community of interest was and what were the smaller communities of interest we included. So this included a small Armenian, refugee population, and this included, right? So that we could describe all of the different communities of interest who had testified before us, and that we were able to keep whole within a single district. We had to justify when we split cities, and then where we split them and why. We had a large South Asian population in the Bay Area that we couldn't fit into a single assembly district, and we had to justify why we split them and where. So stuff like that. So it actually required us to describe these communities of interest, if that's what we were using to justify why we drew the district that way. It wasn't always necessary. For example, in the northern part of California, which has very sparse population, we were just able to put a bunch of counties together that were all in agriculture or all on the coast. But again, we still had to describe why did we group those particular counties together, right? And so, so that was the one thing, the public comment that I made when I read this last redistricting task force report, was that I was happy they did a report, because they're not required to, but they didn't actually provide any rationale for why they drew the districts they did. They just simply reported population deviation. They didn't explain why they did it. So it was purely descriptive as opposed to any kind of justification or rationale. So forcing the body to write a report that describes how they created these districts and what communities of interest are in them and who they had to split and why, I think provides an accountability mechanism like nothing else. So I'm a big fan of that. I know that it took us a long time to go through and feel good that we had actually done right by Californians all around the state, that we had complied this ranked order criteria for every single district and could justify it.
And I know that there is obviously a rationale. I've spoken with some of the redistricting task force members, and they had a very clear rationale that was, justified by the kinds of things that are listed here, communities of interest and things like that. So, it does take extra time, and they weren't compensated. I understand that. So I think that there's a little bit of a companion to that, right, is the recognition of the immense amount of work that it takes to be a part of a commission like this, even if it's not a contentious process. It takes a lot of time, and by recognizing that, it might be also a little easier to make a request, like putting together a report with the rationale that they already have. They just, just documenting it.
Yeah. And then the only other thing that I had thrown out there that I was trying to think about why we wouldn't just comply with state law. And the only thing I could come up with were things like cultural districts. Like, would that be something that we would want to protect in San Francisco? And my thought on that is, I don't know that we would need to protect them especially, like call them out, but it could be used as justification as to why this is a community of interest.
Right.
So you could say San Francisco recognized this area as a cultural district, and that's part of the reason that we believe this is a community of interest. To give you an analogy, what some people did as they were trying to justify their community of interest, they would bring us school district maps or utility map, other maps, right? That showed they were in this district together to show us why it was a community of interest and to show that there was precedent for recognizing an area, right? Now, not all of those districts are made based on, population and electoral reasons, right? So why you might draw a certain kind of district may not be the right justification, but it's still justification, right? And if you can make your case to the commission and convince them that this is a reason why, it is a real community of interest, that's why you have people on the commission to try to make those kinds of judgment calls. And so my thought is, I was just trying to be comprehensive when I would raise these questions originally. I was trying to think of anything that San Francisco had that was special, and that was one thing that I could think of. But I also don't think it needs to be called out separately. I think if people want to use that as part of their justification and make their case to the IRC, I think that it's evidence, right?
Well, I think the most important part is the report establishes accountability, and having to have the report means that you have to justify what you're doing. And I think that's for me, that's the most important part. It needs to be, as Commissioner Parker said, not everyone can attend this, so having a report that outlines why certain districts were created and why things change is going to be essential. And so to me, that's the meat that needs to be there.
Do we want to talk about any other, I don't know if Commissioner Levelsey, if you have any other comments on the other areas related to this, or if we should just move on to the next?
No. Okay.
Just looking at the questions, of course, I'm also support the update in 764 to have the prohibition that we had, which is not considering incumbents, candidates for office, where they live, or political parties.
Oh, it
because
says
that's-
prohibits.
It
incumbency
prohibits it,
protections.
yeah.
Yeah.
We actually deliberately didn't even look at where people lived. We deliberately blinded ourselves to that. And as a result, we ended up drawing a bunch of elected officials in the same districts. So that's what happens when you don't look at it, when you're not gerrymandering.
Okay.
Yep.
Okay. The next area is funding. Key question is, what is needed to adequately resource the work, as well as decrease barriers to public participation? The quote that I listed here in the yellow box is from the city clerk's office report that you can find at the end of the redistricting task force report. And that is that in the future, it is recommended that a department or division is established to provide a structure that increases the ability of a team of individuals to plan and problem solve at a high level. The main areas that we could discuss here are stipends for members. And within that, what size stipend is meaningful enough to enable those of lesser means to participate and recognize all commissioners for their time? How can compensation be adjusted over time without putting another measure on the ballot? Budget to support the process. How much independent budget is needed to fund needed aspects of the work? For example, a mapping consultant, outreach, interpreters, things like that. Again, there are the city clerk's recommendations are very full and rich if you take a look at those. And then generally, what parts of funding need to be included in the charter versus put in place by the Board of Supervisors through an ordinance? And should there be an automatic augmentation in subsequent redistricting processes? Because obviously things get expensive over time. So those are the main questions. And then a couple of other notes. The Brennan Center, who you'll see quoted in some of the reports that I have linked at the end of this whole deck, I believe that this is maybe from the 2017 redistricting report, said that with funding secure, the commission may draw the district lines without feeling beholden to the legislature's power of the purse. So some of the recommendations here are like fund it up front, not just later when you are happy or unhappy with the process, right? Like upfront, allocate a certain amount of funds. And then I just wanted to actually read a little bit more excerpt from the city clerk's report, who said, during the 7-month process, the entire leadership of the clerk's office were committed to planning the critical administrative objectives of the task force. The clerking duties were done by an assistant clerk from the clerk's office who was still assigned to a committee at the Board of Supervisors. Additionally, backup clerks, both remote and in person, each had their regular Board of Supervisors duties to perform, which is extremely draining on department resources and caused focus to be diverted from the business of the Board of Supervisors. The clerk's office did an extraordinary job of stretching the limited staff resources on hand while executing hybrid meetings at the Board that had already doubled the workload of the department. In the future, of course, that's a unique time. We're at the beginning of a pandemic. In the future, it is recommended that a department or division is established to provide a structure that increases the ability of a team of individuals to plan and problem solve at a high level. At the very least, 2 clerks should be assigned to the responsibility of clerking the task force, with not much else on their plate, given that meetings may occur on consecutive days of the week. Staff who are assigned to the task force, especially the clerks, should also have an intimate knowledge of the city neighborhoods, streets, and districts. In order to accurately capture the voluminous comments and discussions on the various areas, the clerks must be able to articulate those concisely. It must be remembered that supporting duties of staff are in addition to regular duties, and the business of the city should not be disadvantaged. And then on our chart here, current San Francisco law, there's no stipend for members. Operations of the task force are supported by the clerk of the board and the Department of Elections with limited augmentation in budget. AB 1248 would require a stipend, the amount to be determined by the local jurisdiction. It requires provision by the local jurisdiction of, in quotes, reasonable funding and staffing of the IRC. There's nothing related to funding in the Fair Maps Act. In the Promise of Fair Maps report, they do recommend that there are required stipends and that jurisdictions invest resources in recruiting efforts for large, diverse pools of candidates and also fund community benefit organizations or CBOs to engage underrepresented communities in local redistricting. The recent redistricting task force here in the city echoed the clerk's recommendations, saying that the city should establish a temporary department to support the task force and its needs. For example, a chief of staff, admin support, media coordinator, a sunshine ordinance expert to manage requests, because there always are a lot, but at least 2 clerks if funds are limited, and that the Board of Supervisors should allocate funds at the outset. And then finally, the State Commission has a stipend for members. Currently, it is $378 per diem. It's required to appropriate, the state is required to appropriate adequate funds, and they may hire staff and consultants. And that's it.
So I would add that it's a unique structure for the CCRC. It's actually a state agency on its own, which has some pros and cons. There's actually a lot of overhead trying to run a small agency at the state level. So, but because we're completely independent, we had to hire our own staff. Once the state auditor had completed the vetting and selection process, they were kind of like, okay, go do it. Go hire your own people. But we did have our own general counsel. We had our own, executive director who hired all of the support staff. And I think that's difficult to do at the local level. And so but unfortunately, the current process is kind of at the other extreme, which is said, okay, we're going to give you help from the city attorney and the clerk of the board and Department of Elections, but we're not going to give them any extra money. And so even though this is a gargantuan task that happens only once every 10 years, you're just going to have to figure out how to do it with the existing resources. And I think that's what we heard from the city clerk came and addressed us from Ms. Calvillo. And it was just crazy because, of course, as all of us know, the Department of Elections had 4 elections running, that year too. And so they were juggling things back and forth, trying to handle it on top of the exceptional workload for the Department of Elections. So, so I do think, consistent with the most recent redistricting task force, it makes sense for them to have dedicated staff. They can still be supported by other departments, but they need some dedicated staff. And, part of the reason they were so late, outside of everything else that happened during the process, is they couldn't get support from the city clerks to, get, the same problem we have trying to find a room. They were dealing with clerks who had existing Board of Supervisors duties, and so they couldn't schedule a meeting for several weeks. And I think what the Promise of Fair Maps report is pointing out is that you need a budget for outreach. And what happened, I think I've shared with you folks before, what happened with the first CCRC is that the state auditor had spent our entire budget before we were even selected. And that's because they had no idea what an independent process was going to cost. And so they put in that line that required the legislature to appropriate more funds, but we had to go and get it from them. So what we just remind you that we heard from the chair of the Long Beach IRC. They actually budgeted over 3 years. So they had a 3-year budget. And the first year was, outreach and outreach planning, and then the staffing up and setting up the body, and then the actual mapping process. And so there are several components. And I do feel like this is too detailed to put in a charter amendment. Even the pending state legislation basically just says reasonable and adequate. But we could, put some guardrails around it and say that, they must account for, outreach. And for example, that's a lot of what's in 764 is ensuring that a proper plan is actually written, and that community-based organizations and other organizations that understand their local communities are consulted and involved in the outreach process to build that large competitive diverse pool. Otherwise, you're not going to get the quality commissioners out of that.
Mm.
So I think stipulating that, reasonable funding should include some dedicated staff. I don't know how specific we should get in terms of specific roles. I don't know if we have a strong opinion on those, but, I do feel like they at minimum need dedicated clerks. And if they're going to continue to be, partially supported by city departments, those departments need augmented budgets that recognize this is a once in 10 years kind of task, and they can't just like figure out how to make it work with their normal allocation.
Right. That's going to be a challenge. Well, looking at the deficit, but I think I like the promise of fair maps, required stipend, invest resources in recruiting efforts for large, diverse pool. I'm not so crazy about fund CBOs to engage because some of our CBOs have political missions. And so, but I think being clear about a stipend, I think we are asking citizens to do something that's very important in the representation of all members of the community. And so I think where you put your money shows what's important to you. And I think asking people to do this without a stipend, I think a reasonable stipend, and I think perhaps it should be weighted. If you're someone who has means, should you really have a stipend is a question. So maybe looking at income levels, asset levels. I don't think that's unfair. And making sure that there is a dedicated, reasonable staff for this work. And if at all possible, any local agency that's tasked with assisting should have an augmentation to their budget. I mean, to me, that's just
Obvious.
right.
I mean, there was some augmentation. I mean, the Department of Elections got a budget to help hire the line drawing consultants, the technical consultants, and then I think the clerk got a small budget for something as well, but it was not nearly enough.
Interpretation,
Yeah.
limited, like
Language.
4 hours a meeting.
Yeah,
Yeah.
language access.
Mm.
So I think recognizing that this is a big undertaking and it cannot be done as business as normal.
Mhm.
So I heard equitable stipends. The budget must include outreach. There should be some dedicated staff. And any assisting city department should have an
City department.
appropriate augmentation. Does that make
Mhm.
sense?
Yeah, I generally what we see on this whole chart, I think generally seems like a good idea. Like I generally think, okay, the redistricting task force that just finished their recommendations. Yes, that makes sense. They just lived it. They know what's needed. I think
Right.
it makes a lot of sense to go with those. The clerk also so detailed in some ways. I could imagine that our ultimate recommendations include read the clerk's report and you determine what should be in a charter versus not, because we don't want to, some things are appropriate there, some things aren't, but
Right.
read those reports as far as recommendations. Those are really important. But also these other, as Commissioner Levolsi said, this promise of fair maps. I'm trying to speak too quickly. Promise of fair maps report, and what's included in current funding or current legislation. That all makes sense. And I would support doing that, like a recommendation could be follow these, decide what goes in the charter, what doesn't. My wondering, the idea of equitable stipends, is interesting and, and I generally like that. And like, I'm curious how much will that save? Is it, because everybody's putting effort in. And so to me, it's maybe there's some exploration of, what would it cost to do that versus not? Because everybody's putting in a lot of effort, and
Right.
it's expensive to
point.
live here.
Yeah.
But if we were in a budget situation and we couldn't do it all, then yes, like, let's make sure that those who really need it and couldn't participate otherwise, yes, totally. I totally agree with that. And the amount, like, some of the things that stand out to me, which I generally agree with, that we heard in one of our panels when Reverend Townsend was talking about and asked the question that I've thought about too, is what's the right amount for stipends? Because sometimes we provide those and it feels good, but what's enough to actually make a difference to someone who might not otherwise be able to participate? Sometimes I think of these stipends as they're never going to actually it's not a job, it's not the equivalence of a job or a part-time job even.
Right.
However, it can help with things like paying for your parking fees and your transit fees and your babysitting and, whatever else it takes to do that job that would have otherwise been out of pocket, it tends to help with that. But that is the question for me, is what is the right amount? Because this is paying them per diem for the meeting days, right? Not all of the days that you're actually doing the job.
Well, so I can share my experience at the state level. We had, when I did it was 300, and it increased by the cost of living, so that was stipulated. It was 300 per working day, and then we had to define that, and so we actually defined it. That basically said either it was a day that we had to meet, because sometimes our meetings were 10 or 12 hours, right? Or it was a minimum of 6 hours. Like if you worked 1 hour on one day and then another hour another day, that you could combine those. So, and there was also discretion as to what you claimed. So, we had one commissioner who claimed time for organizing his binders, right? And most of the other commissioners didn't claim time for stuff like that. So there was certainly some personal, it was an honor system. Obviously, it was very obvious which days we had meetings, and some people had to travel and some people didn't, depending on what part of the state it was in. But, you couldn't charge for, more than the actual day, right? And then there was that stipulation, if you had to put in a couple hours here and a couple hours there, that you could group it. Like a number of us had outreach duties. So I did a lot of public speaking, and, that would be maybe a couple hours one day. And so in order to get credit for that, the point was you couldn't just claim that. You had to do other work to get up to a minimum of 6 hours. So that was the rule that we came up with. The 2020 CCRC didn't have that 6 hour kind of limit. And so again, honor system. But it did allow us to differentiate, for example, two of us who did most of the final report. We could actually claim time for that because we put in a lot more time than other people. So there were situations, we had several commissioners who were assigned to deal with the attorneys because we had a bunch of lawsuits we had to deal with. And so they got to claim that time. And I think that was one of the complaints we heard from Ms. Gutierrez, from the chair of the Long Beach thing, is that they were only allowed to claim meeting times. And so she commented that as chair and the vice chair did a lot of extra work and they weren't able to claim that. So, so I think, providing some discretion to let the IRC come up with rules for themselves, to police themselves. I think there was a pretty big variation in what, at least on the 2010 CCRC, what people claimed. So there was a pretty big variation because people put different amounts of time in. Right. And so, so I think allowing for that flexibility is good, as opposed to, say, just a monthly stipend, where everyone gets the same thing. And I do really like the model of be the jury because there's precedent in San Francisco for doing an equity-based thing. And that's one that you have to apply for. And so
Mhm.
there's that thought too, is that,
Mm.
you know, that if you want to make it a means test, you let people raise their hand, you know? You could do it the other way too, where you could opt out.
Mhm.
But I mean, I think your point is fair. Even if you have a good job, you know, you're still taking.
You're doing work.
You're doing work and it's extra time and you should be recognized for that.
Mhm.
I also think that expenses should be covered. So one of the things that our travel expenses were covered for sure. So we were able to, you know, claim standard state, you know, per diem for meals and when we were traveling and things like that. You know, there's not a lot of travel within a local jurisdiction, but what,
Coverage of meals and, or
yeah, if you have a meeting that goes,
parking.
yeah.
You know, there are,
parking.
I think, and sorry to interrupt you.
No, it's good.
I think San Francisco, those are the kinds of things that should be thought about.
I agree.
Because as a statewide, there's traveling long distances. You know, San Francisco is an expensive city. It's an expensive place for childcare, for parking, for food, for these things. So I think a way to compensate people for those things, like if you're meeting all day,
Yeah,
you should be able to get food.
right.
Parking.
Local transportation.
Local transport, I was just going to say, maybe Clipper cards with a certain amount that allows for people to be able to use public transportation to get to meetings.
Yeah,
Because that could be something that could be done that, you know, we could avoid the parking in some ways if everyone gets a.
yeah, you
certain
could just
site.
give everyone a Clipper card and then say you manage it, right? So, I mean, I think these are some details I don't think we need to get into, but I think
Right.
saying that reasonable expenses should be covered. I don't think it should come out of per diem. One of the things we really struggled with on the CCRC is we had young mothers on our commission and they had significant childcare expenses and we could not figure out a way to expense that under the state regulations. And so that was one of our recommendations is that, you know, future commissions figure out how to deal with that because we could not under the normal state, you know, when we were just subject to all the normal state, you know, travel policies. We were not able to
Right.
compensate our commissioners who were mothers who had to get extra babysitters or really impose on their partners.
I would be very curious if there was any way for the Board of Supervisors, when they get to this, to find out, you know, to do a bit of a poll or focus group sort of thing, you know, to find out if there was no stipend, would that count you out? And then what would be the right coverage? Is it that there is transportation, childcare, whatever, you know, a stipend of $378 per day, you know, something like that? Would that make a difference? And would the answer be yes? There might be some people who say no. And to be, I mean, to be realistic also, the schedule that is demanded of a commission like this, there are some folks who will never be able to participate because they have hourly jobs that they cannot change at the last minute if the meeting goes longer than it was supposed to, or if there's another meeting called the next day because the work wasn't finished. Like there are some people who will not have access to this kind of an opportunity, and that is real.
That's just
And so finding other ways for folks like that to participate and meaningfully give input, of course, is important. And therefore, funds to support that kind of outreach are important, that they can participate in an asynchronous way by filling out a poll, by doing, you know, giving written public comment in an easy way. You know, there are ways to include folks who are just not in a position to have a schedule that will allow for participating in a task force like this. And there might be some people who are on the edge, have the flexibility, but have major caregiving responsibilities, not even small children. Sometimes it's elderly parents.
Elderly parents,
You know,
absolutely.
or people who are chronically ill, you know, there's who they care for. So there are people, and they have a lot to say and want to contribute. So So not everybody will be able to be on a body like this. It's just not realistic for some folks, and finding the ways for them to still participate if they can't.
Yeah.
So,
And Commissioner Parker, I think I really appreciate you bringing up the elder care. So I think any recommendation would be should be to consider those extra expenses that people may need support in order. And as you said, it's not going to be a body for everyone, but for those who want to participate and have the schedule and ability, but are encumbered by a responsibility of taking care of a loved one, be that a child, a spouse, an elderly parent. I think as a city, we should seriously think about supporting that.
Okay, so I think it's important to say there's the stipend, and then there are also reasonable expenses that you incur in the course of this work.
Yep.
Yeah, because all of our expenses, like I said, with the exception of the caregiving expenses, were covered by the state. And I will say that even though we're spending a lot of time on stipends, that was the smallest part of our budget. The vast majority of our budget was for litigation defense.
Yeah.
And, you know, everything else. Like I said, the state auditor spent, we were allocated $3 million by the Voters First Act, and they had spent, I think, 4.5 before we even got started. So that just gives you an idea how much the outreach and recruitment piece of it was. I think the stipends were like maybe $1 million total or something. It was a very tiny part of the
Well, you
budget.
can do a cost benefit, analysis to something like this too, right? How does it decrease barriers, and how does it have create a better, inclusive process, like all of those things, we're not even just talking about on the stipend side, but adequately funding the process on the agency who is supporting it side, on the clerk's office side, all of that creates a better engagement process for everyone to be included in. And yes, every time you fund something, there's something else that doesn't get funded at the city. That's just the reality. And so it's just deciding, weighing those things, about what's important. And in the scheme of a massive budget, we're not talking a huge amount. There's always trade-offs.
Yeah,
Right.
yeah. I mean, it will cost some money. So just to reiterate, since I'm the one who has to summarize this, what I heard was reasonable stipend, that equitable stipend that allows for differential effort, if that be a fair way to say it. And also related local transportation, meals, and caregiving expenses that might be incurred in the course of the duty. And then just to reiterate that adequate funds must be set aside for outreach, particularly to underrepresented communities, whether you want to fund, we don't have to get into whether they fund CVOs to do that or not, that there should be. We have, as we know, plenty of departments in the city that do that regular kind of outreach. And there should be some dedicated staff, and any assisting departments should have a budget augmentation.
Yeah.
Okay. Good.
Ready to move on?
Yes.
Okay, this is just a small one. Commission processes. How can the commission be properly supported and trained?
Did you advance your slide?
Oh, I did. It's not showing yet. There we go. It's slow. How can the commission be properly supported and trained, transparent, and inclusive of diverse public input? This is a quote from the 2017 Redistricting Commission's report that says transparency and public let's try that again. Transparency and public participation in redistricting are essential to drawing better district boundaries, maintaining public confidence in the fairness of the process, and building community support for the final maps. The areas we might consider: training and support. What training and preparation should the task force have and when? For example, legal training, sunshine ordinance training, technical training, redistricting criteria training, best practices that may not be, listed in the charter, but are just generally best practices on process. What staffing support and additional resources do they need to be effective, which we did cover that to some degree, but that is certainly part of it. Then including the public. How can the task force meaningfully include the diverse community in the process? What additional resources are needed to do that? How do meeting times and lengths affect this? Drafting the map. What should procedures for the mapping process be? What works and worked well, and where can improvements be made? Decision-making and voting, specifically here talking about the voting threshold, simple or supermajority. Transparency, what should be required in the decision-making process to ensure transparency. For example, touched on this a little bit, a written rationale for maps, what types of communication should be restricted, for example, ex parte, intra-commission, et cetera. And then missed deadlines, what should happen if final maps are not approved as required by the deadline. In the voting, just to make a quick note on that decision-making and voting line, I'm just separating those. So there's a voting on business matters, that's the decision-making, just sort of the normal operations of the commission. And then there's a voting on maps. So some bodies like the state commission had a special supermajority because they had a different configuration than we would have here in San Francisco. They had a special supermajority. We'll just, for here, let's just call it a supermajority, only for maps and vendor contracts, as opposed to the regular procedural decisions within the operations of the commission. And then to our chart, current San Francisco law requires a simple majority to approve maps and says that they shall make adjustments as appropriate.
Again,
I did. It's okay. I should just look at the thing to make sure it actually shows up before I start talking.
yeah,
I did forward it.
I believe you.
It's just very slow.
Oh,
There we go.
go.
Okay. Current San Francisco law requires a simple majority to approve maps, and then the task force shall make adjustments as appropriate based on public input at public hearings. That is all that the charter says about processes for the task force. Pending legislation for the state. AB 1248 prohibits ex parte communication. The existing deadlines and requirements, et cetera, for legislative bodies apply. They're required, commissions, IRCs would have to publish a draft map 7 days before a vote on those maps. There's a minimum of 3 public hearings before final map adoption. No incumbency or political preference in districts, which I guess that's repetitive from a different slide. A quorum is 9 people, and 9 of the 14 people that are would be part of that would be composing the IRC through that legislation. 9 affirmative votes is required for any action. So quorum is 9 and 9 affirmative votes are required for any action, 9 out of 14. In AB 764, there is a minimum 1 public workshop required and 5 public hearings required. IRCs must adopt education outreach plan by March 1st of the year ending in 1. So for instance, 2031, and other details that I did not go into here because there's not room. Also, the AB 764 allows for remote and in-person comment to allow more participation. And also oral and written public comments. I just want to note this is not written here, but they are available. They are supposed to be available on the Redistricting Commission's website. So when the commission receives any oral or written public comments, they're required to be available to anyone to see on the website. I like that. I'll just say that really quickly. The Fair Maps Act. IRCs must hold a minimum of 4 accessible public hearings. Make good faith efforts to include underrepresented and non-English speaking communities. So I would just detail that means translation and interpretation. It requires for the commission to publish a draft map 7 days before the vote, same as this AB 1248 does. Make all public comment available. If the final map deadline is missed, then the final map drawing goes to the Superior Court. The Promise of Fair Maps report recommends that there is an increase in the minimum number of hearings and workshops from 4, so that's Fair Maps has that 4, I just said that, to a minimum of 6 to 10 hearings and workshops. They recommend that IRCs must provide in-person and remote options for public comment. They require the posting of all written public comments and recommending requiring redistricting website be up for at least 2 weeks before the first hearing. Shorten the timeline for publishing the video and minutes to 1 week from when they were received, or when they were after the meeting happened. Also recommending that the IRCs adopt an outreach and education plan and also fund community benefit organizations to engage the community. So this is very dense. Hopefully you all are following along. The redistricting task force here recommended that the task force draft bylaws and tentative schedules and proposed timelines, or I'm sorry, let me start again. They recommend that draft bylaws, tentative schedules, and proposed timelines should be presented at the first task force meeting. So presumably that means that the agency who is supporting the task force has gotten that together as somewhere to start for the task force. Mapping training should be provided very early before mapping begins. That makes sense. Meetings should begin earlier in the day and run more efficiently. More robust outreach into communities is needed. A clear scope of work with consultants is needed. There was a bit written there in the report you can look at. And then also they recommended that methods are developed to protect members from attacks and threats, and also that members are shielded from inappropriate influence in the process. Let's see, hold on. I had some other notes here. I just want to make sure. As I was reading the charter, I just want to add a little bit more clarity. I already said there was really not a lot about processes in the charter. The one line says that they should use public input, and the simple majority is just standard unless it's defined differently. So it's just standard, right? It's not actually listed there in the charter. It's just standard unless otherwise defined, to be clear about that. They did establish, just out of practice, not because it was required or not required in San Francisco law, the most redistricting task force did establish a lot of processes themselves. I think there was a lot of agreement early on of the members on the processes they were setting up. They established structures in the beginning, for example, electing officers, adopting bylaws, setting schedules, getting briefed and trained. They assigned, this is all in their report, by the way, they assigned members to lead particular areas of work, for example, community outreach, social media and website, data and mapping, budgeting, community input management, et cetera. They also relied on a consultant to assist with outreach and participated in this themselves as well. They advocated for language access, and they were really frustrated when there wasn't enough budget to support more. I know there was a lot of criticism about that, and they didn't have any control. They didn't have the budget to have more. They also released a free redistricting tool for the public, along with a training video to help the public with map drawing. They held 2 district-specific meetings in each supervisorial district, and they iterated on maps with support from consultants, including doing live drawing. And then they also made some recommendations for future task forces when working with the consultant, as I was just referring to. So that's all in their report. You can read about that if you like. There are also Civic Edge that was the consultant hired to help with community outreach. They had a little bit in their report that is in the larger task force report document. And some concerns that they received were around meeting schedules and collaborating with the community on what those meeting schedules should be, that there are more languages needed in interpretation and, those in-language meetings as well. And let's see, regarding meetings, the task force specifically said that future iterations of the task force should consider various methods of running meetings more efficiently while allowing for more robust participation, including more focused public comment, better facilitation of discussion and action, and even recessing until the next day if necessary. So this is obviously means that the redistricting task force their processes are very dependent on who is appointed and how they decide to work, as opposed to something that's documented and required in some way of them in an ordinance or in a charter. And then I'll just note this, the California Commission, and then I have one other note as I was doing some of this research about those majority and supermajority thresholds. So the California Commission requires a special supermajority for maps. That's 9 of 14, and that means at least more than or equal to 3 Democrats, more than or equal to 3 Republicans, and more than or equal to 3 others who are declined to state or independents. And they're required to comply with the Bagley-Keene Act. There's 14 days notice for public meetings, 14 days of comment on the first draft maps, and 7 days on others, 3 days on the final maps for public comment. They're required to conduct public outreach and providing the public with mapping software. They're prohibited from ex parte communications, commission records are public, and they must publish a report justifying the final map. So the last note that I wanted to make around majority versus supermajority. So there's a lot of different points of view on this. Some folks think that a supermajority forces collaboration and creative problem solving to get closer to, though not forcing, consensus and considering what's best for voter representation rather than personal preferences. Some think that a supermajority could paralyze a body and make it more likely that a final map deadline would be missed, thereby pushing the decision to the court, who hasn't just done all the work that the commission or the task force has done. So there are various points of view on those 2 thresholds. Okay, that's it.
Thank you, Commissioner Parson, for that very dense explanation.
So maybe we can start with the voting threshold, just as it's very concrete. So my experience was the former, that it really created an ethos of consensus and collaboration and creative problem solving when we saw that we didn't have the votes. It caused us to really listen to each other so we could try to convince each other. So we could, get that. And then, in the end, and that's why it was so heartening for me to hear Dr. Sadhwani say that they essentially did the same thing, where they operated by consensus, because that way, by the end of the process that you're going to get your 9 votes. Because otherwise, I will tell you, there was one point in time when we thought that we were not going to get enough independents, because it was harder because there were only 4 of them and we had to get 3 out of 4. And we thought 2 independents might vote against the map, and it was pretty stressful. So, that was why working by consensus all the way through, similarly to how we're discussing this among the 3 of us, was really good, because then you knew you had it at the end. And that's what Dr. Sadhwani said, that they were not surprised they had a unanimous vote, because they had worked that way all the way through. So the comment that, that would just cause them to miss the deadline, that was a comment from one of the former redistricting task force members. And that was, one of the contentious ones. And so they, had those battle lines drawn. And I guess my concern for San Francisco is, even if we increased it to 14 plus 2, as we've talked about, making it 9 just makes it a higher hurdle that they have to get people on board. Because my concern is what we saw happen this last time is that, once you've got the 5 people who are always voting together, they basically had no reason to listen to anyone else anymore.
Right.
And we want this body to listen to each other and to listen to the public and to be able to be persuaded, and to listen to somebody else's judgment call. And that was something that, I knew on my IRC that we were going to be fine, because in our very first vote, the vote swung from, even split to 8, to, to, 8 or 9 on one side, and then it flipped because we were having this very intense discussion and people were convincing each other. And I think what happens if you have a simple majority, and in this case where we had political factions, it just means that you're no longer protecting the minority, right? And so I like a supermajority. I think 9 is not onerous out of 14. And it doesn't have to be special because it's at the local level. But that means you need to convince at least 8 colleagues of your point of view. You can't just steamroll over them.
Right.
And so I would say it just made a very big difference for us because we were constantly keeping in mind that we were going to have to make a big vote at some point, and we needed as many people along the way raising their hands all the way through as we were going through 177 districts across the state, right? Because you disagree on one district, you vote against the whole map, right? So I can just share that experience.
I think when we think about, when we talked about the types of skills that members of the commission would need, I think the consensus is really important because we want, in my opinion, we should be recommending that we foster consensus, that you don't have factions. And if it's a situation where you have to make sure as you're going along the way that you've got everybody on board, you have to discuss it and you have to convince each other, that will build consensus. And I think it'll give the community of San Francisco much more confidence in the process.
And I think I want to distinguish it from, that you want people who are just going to agree with each other, because that was not the case.
Right.
We had fairly violent disagreements at some point, but
Wow.
but the
Okay.
point was that everyone got their say, everyone got a chance to try to convince everyone else, and then people were moved
Mhm.
and they allowed themselves to be convinced.
Mhm.
And in some cases, I remember very distinctly one of the commissioners who happened to be the youngest commissioner, and she, was, when she first spoke, she was a little, you made that comment, that I don't know, I'm, probably in the minority here, whatever. And she convinced us to change our minds. I mean, she moved the whole commission a totally different direction. Um, and I think that's what we want to encourage, is
Right.
the ability to listen to each other, collaborate, and instead of just disagreeing, find a creative way to solve it. Like we did what we called these like circular rotations of population, because, everything's a puzzle piece. They all have to fit together. So once you would, adopt new borders to adjust around communities of interest in one district, it changes the borders of the neighboring district, right? And so we would move the population and rotate it through several districts to find the best combination that would, keep as many communities together as possible. Because, you're accommodating one community, it means you might be hurting another community, right?
Mhm.
So that was something we were very conscious of, was looking at where we could do the most good, and making those trade-offs to say, hey, this is a better overall map. It's not just us against them. It's not that simple, right? So that's the creativity that I'm talking about, is you're going to have to make difficult trade-offs, and rather than just saying, well, I have the votes, so I want it this way, You know, it's like, no, you're going to have to talk to me about it because I'm not happy with what you did to this community in this neighboring district. How do we fix it? Right? So that's what I would want to see at the local level
Mhm.
as well. It's that kind of collaboration to like, how do we fix it?
I think what what you were just saying resonates with me, and actually was kind of say something sort of similar, is that I think that the qualification is not that you're somebody who's willing to be consent in general, but that you will come to a conversation as a good listener, as a creative problem solver, as a critical thinker, you know, as collaborative, you know, those kinds of things that are, yes, we've already discussed the last time we met, are their subjective qualifications, right? Of figuring out how to identify those kinds of qualities in candidates. But I think those are the kinds of skills we hope that this body has. And it's just, as I'm thinking and listening to you all talk and just thinking about all of these different points within commission processes, it's also just striking me that there's this full scope of all of these different components we're talking about that sort of complement each other, right? Is that when you are creating a body that is compiled through a fair selection process, that has folks who have some sort of minimum qualifications, you know, and want to be civically active. And when you're resourcing the effort so that you have an agency who is running this process, who can also support processes in useful ways, you know, that when all of these things are working together, they're complementary to result in something that is hopefully a process that the public can trust because it is transparent. It was, you know, and just the way that it is set up, hopefully allows for trust building. So yes, I agree. I also wanted to just point out that, I mean, I guess what we're also talking about, a majority vote, if we have, let's just say, because I think we did sort of at least get close to saying maybe this 14-8 plus 6, you know, that might be okay. I know we discussed that, you know, of having the right, kind of these minimum qualifications in place. 8 people would be a majority, and then 9 would be a supermajority. So it's a difference of 1 person. It's not a lot of
It's not
different people.
onerous.
Yeah,
Mhm.
no, it's not.
Yeah.
And it does allow for, you know, minority to register
Sure.
discontent, right?
Mhm.
And what the way we handled it on our IRC is that we tended to not vote on things along the way. People who were unable to move the rest of the commission, they would say, well, I see that the will of the commission is going this direction and I'm willing to move on. And so that way, you know, because we clearly defined consensus doesn't mean everyone agrees.
Mhm.
It means that people have been heard and
Conclusion.
they've reached a conclusion. They see what the will of the commission is and they're ready to move on. They don't have to beat a dead horse and continue to, you know, rail on it. Right.
Mhm.
And so, so when I say that we work by consensus, it did not mean that we all agreed.
Yeah,
But
of course.
it meant that people conceded that a supermajority had landed somewhere else after hearing them say their piece. And they felt heard and they had put their disagreement on the record. And then we moved on to the next topic. And that's how we were able to get through 177 districts because we didn't all agree
Right.
on everything.
Right. And just to clarify my statement, it's the skills are the ability to articulate your point of view, to listen, and to be okay with, we've all discussed it, we've all heard our point of views, and now we've decided on this. But I think you can only do that when you have, you know, that level of required, the supermajority. Sorry, it's been a long day. My words are escaping me. That's, to me, that's fundamental for this to work, especially in San Francisco.
Yeah. And we did have that bifurcation where we only had that special supermajority on on maps. And then it was
Oh.
just,
Mhm.
it was, I think it was 9 to make any decision, but it didn't have to be that special supermajority. But again, we mostly operated by consensus, so
Mhm.
most of the other stuff didn't matter
Mhm.
anyway. But
I think you also said something that I think is also key, is that if we did if we recommended a 9 supermajority, it does still allow for minority discontent, right? It still allows people to disagree and the process to move forward. And sometimes that, I think not sometimes, I think that is really important,
It
you
is.
know, and for having people to be able to, document that. And if that's not, it's maps, that that point of view can be represented in rationale. And that's, I think, an important part of community engagement in our democratic processes and all of that. And so that, I think that's a really good thing.
yeah, majority rules, but
Right.
minorities have rights.
Right.
And that is democracy.
Right.
Okay, so that's the supermajority. I think we're pretty comfortable with 9. We've talked about the report before. Ex parte communications,
Mhm.
that is something that is consistent with what the redistricting task force members requested in their written report and also in person in front of us about being protected from political influence.
That was very clear.
You know, if you're not a political appointee, then you can't be summoned. So that's part of the independent selection process. But in this particular slide, no one was allowed to talk about redistricting matters outside of a public meeting. So, elected officials actually came and addressed the commission. They had to do it in a public meeting with the same 3 minutes or 2 minutes, whatever it was, that every member of the public got. So there were no secret meetings, basically.
That's key.
And if you did have a meeting, you had to disclose it. So, I mean, that happens. People have a conversation. And I had friends who would start talking to me about their area, and I'd say, I'm sorry, I'm going to have to ask you to put it in writing and post it on the website now, because I'm going to have to disclose that I had this conversation with you. So please stop talking and write it up as a public comment and submit it to our website. Right? So that way, everyone's hearing the same stuff. Everyone's seeing the same written comments. So I personally am in favor of that. I think it was really important as an insulation mechanism. I mean, there were public officials I knew that did not talk to me the whole time I was on the commission. So I personally think it's a good idea. Yes?
Yes, I know. I remember very much the representatives from the last redistricting and the pressure they felt. And I think the goal of this is to prevent that. So having it being an independent body and a prohibition on ex parte communications is going to be key to keeping it independent. So yes, I agree.
Yeah, well, one of the recommendations from the task force also was to shield them from inappropriate influence. They requested that. I think in some ways can make I mean, it can be complicated to have every conversation about a topic in public. Like it just, it's not an easy thing to do. And it's a public body that has public accountability and transparency is necessary. And sometimes it's helpful when there are guardrails, put around you that say like, I'm sorry, you just have to bring it to a meeting. Like I just have to have these, it can shield people in a way that can sometimes be appreciated and make the job a little bit easier.
Yeah. I mean, we could do like outreach stuff, right? Like I said, I was sent out to do a lot of public education about what is redistricting, how can you participate and all that. But as soon as somebody says, I want my district to look like X, then I'm like, okay, please put it put it in writing and submit it to our website, so that
Mhm.
I don't get called out for having a discussion with you about your district, right? So. So that's on transparency. We've talked a bit about the voting threshold. Oh, I was remiss. There was one other thing in the amendments for the state legislation. They clarified the procedure if the commission misses the deadline.
Oh.
Yeah, and they put some teeth in it. So they did say it would go to Superior Court, and they added a line saying that the court would be empowered to hire a special master to draw the maps.
This is in 1248.
In 1248 or so 60.
It might be 764,
Wow.
but it's one of them.
Okay.
Remember, I read this like 10 minutes before the meeting.
Oh.
But there's a specific procedure now, because remember, we weren't sure, like what happens when you send a Superior Court, then what? So now they actually added a line saying that the Superior Court would be empowered to hire a special master to draw the districts if the IRC fails to meet the deadline.
Hmm.
And I'm sure that was a logistics thing to make sure that the maps are done in time that candidates can run for office. So that was a addition, amendment made September 1st. Some clarification on that.
Mhm.
So I think that's a good idea, because basically what happened in our case is we lucked out that the Department of Elections had a little bit of wiggle room, and they were able to work with the redistricting task force, even though they were 3 weeks late. But if they had been a lot late, no recourse. We have nothing.
Mhm. I think that something, again, these things are all really interconnected is, that we'll talk, I think it might be the next section, is on timing.
Timing. Yeah.
And that's also, I think, a really important thing here, right? Because these are complicated. This is complicated. No matter which way you look at it, it's complicated. And by allowing the body enough time to do its work, I think it gets less likely that you miss a deadline. And if you support it with adequate resources, it's less like, right? Like there's, again, the interconnectedness of a lot of these things, I think can be helpful.
Mhm.
Yeah, I think you make a good point. It has to be kind of a package deal. It's in the same way, talking about a supermajority without knowing how many commissioners you're talking about is difficult, right? So
Right.
that's why when I originally had done my little tables, I was separating these elements, and then I would say, only if this is also true, right? So yeah, it's kind of a package of recommendations.
Mhm.
Let's see, the first thing you had was training. So I think there were a lot of comments that this last particular redistricting task force in particular didn't get a lot of training that other IRCs have gotten. I trained practically every other IRC in the Bay Area, and I mentioned to the city clerk that we had not one, but 2 former CRC commissioners in San Francisco, and neither of us were asked to train. So, so I think just requiring that they get training on certain topics is just common sense.
Mhm.
And in a timely manner. As I said, they should get training on mapping before mapping starts,
Right.
Mhm.
which implies they didn't. For the CCRC, we had required training on the Voting Rights Act and Bagley-Keene and, state hiring processes. We had all kinds of training, and that all happened very early.
I think that this is another instance where looking to the recommendations of the recent task force here are good. I think, again, they know what would have been really helpful for them doing the work effectively, and just requiring that there be some training, and that the task force is formed early enough to allow for training before they're having to hold public hearings.
Right.
Around the mapping. I think I read, yeah, mapping training should be provided. There was another list, I can't remember where it was. Might have been from the section I read from their report. They did some of it, and I think some of it they requested themselves, but they definitely needed some. I mean, how can you be a member of the public and be part of this process without adequate training? So I think they really did their best, given the circumstance, to get what they needed, and giving them a little support, behind them, through recommendations of, please make sure you do this, read their report, see what they asked for, and see what is, just even the list that I have here in the slide, right? Legals, I mean, some of it's required, right? They're a city body, they're required to do sunshine ordinance task force training or sunshine ordinance training, but the legal, technical, all of those things.
Well, we all have to do that training.
Right.
That's because we're a permanent commission. So what I learned is it's often not required of temporary
really?
bodies. And so yeah, so I think we have to actually be specific.
Make that recommendation clear. Oh, I
Yeah.
didn't know that. Okay.
Yeah.
Huh.
I learned that recently.
Okay.
So, so that's a challenge with temporary bodies, that they don't necessarily get the training that even we get as a permanent commission. So,
Maybe the trainings that are required of permanent commission should also be required of the task force.
Right.
there you go.
Mm-hmm.
Okay. So I'm looking at your next thing, including the public. I mean, I honestly think, and I've said this many times before, that a lot of their challenge was they just didn't allow enough time. And that's why they got so crunched at the end. So their own recommendation about having a suggested timeline, set up for them, that is, that was the nature of some of the training that I did for the other commissions around the Bay Area and elsewhere, was just giving them a sense of what the timeline looked like, and encouraging them to, get draft maps out early and et cetera, so that they could come up with a schedule that would work, as opposed to just winging it
Right.
and then leaving themselves 3 weeks to draw the maps, which is kind of what happened. And then that's why they had these marathon sessions.
Right. So coming up more with like an action plan for how back planning, how to get to where they need to be, with maybe not with specific dates, but at least a timeline of where they need to be so that they're not crunched at the end.
Yeah, so I think that's, so that is something that could be addressed through training. And, so basically what we offered when we were being asked to train these independent commissions was to give them the benefit of our experience and best practices. But I think your next category is actually more explicit about actual
Mhm.
deadlines.
Timing.
But I
Mhm.
think part of this, including the public, was, understanding that it takes time for the public to respond to things.
Mhm.
I mean, it took a year before people noticed we were doing this process, right? So,
Right.
there is, outreach and engaging the public, once you've done something, so you can even get the feedback. And so that takes time, and they need to allow for that. And so I think that is a key issue, was making sure there's adequate time. And that's what's behind the deadlines in the state legislation. Like I said, we had a very onerous notice requirement, 14 days. I mean, we scramble now just to do our 72 hours for our meetings.
It's really long.
14 days is really long. We literally had to just agendize meetings because we didn't know if we would need to meet. And if we would miss the 14-day posting deadline, we couldn't meet. So we literally
That's long.
we had to agendize meetings way out in the future just to make sure that we had a standard agenda that was posted that would allow us to meet. So 14 was tough. So they have 7
7.
for local, which
I think it's fair.
that seems reasonable. And the idea of, if you post a map, I mean, it takes people a while to say, okay, do I even agree with it? Do I understand what's going on? I mean, that's why there's a requirement to post a map for a certain amount of time, because people need time to absorb and then react to it. So I think the deadlines that are proposed in the state legislation seem reasonable. Like I said, 14 was really long.
That seems excessively long, but it's also for a state process, when you've got so many people. I just, there's something about the size that
Yep.
I suppose could
We
make that
we
make
did it.
sense.
We did 14 days.
I will admit, like the concept of making sure that there is time before an agenda or map or posted for the public, knowing like I have a very busy job. So making sure that if I had 24 hours notice, I can't do it, right? Like there's just some things that aren't realistic. And so I would need time to look at something. And and what is onerous, like I just don't feel like I have I just don't have the experience of being on the commission to say, yes, this is realistic. Or this would be realistic if you started us early so that the whole process could take longer, so we could allow for the 7 days and the 3 days and all of those kinds of things. And if we could extend the process in a way that allows for that and still allows them to meet their deadlines, then I suspect people would be in support, but I would be curious to hear from people who were involved if they do think that. But that's my logic says that.
Yeah. Yeah. No, I mean, if you look at this poor last redistricting task force, I mean, they were, I think, appointed right before the holidays, and then the pandemic hit, and, they spent a lot of time trying to
Right.
figure that out. And then they had an April 15th deadline.
Right.
And so, they were just crunched on time the whole
Mhm.
way through. They were appointed late.
Right. Well, I think that the redistricting task force, the last redistricting task force, is an example of why you need time,
Mhm.
because you don't know what's going to happen. Of course, no one could have predicted a pandemic. No. However, we don't know what's going to happen.
Mhm.
We know that the virus is still there,
Yeah.
so we don't know what's going to happen.
Still happening.
It's still happening. People, so I do think time and giving enough time to prepare for what potentialities we can
Makes sense.
foresee makes sense.
And I guess I'm just making that point is, I think that was their biggest challenge of being
Right.
inclusive, because
Right.
they literally had to have these meetings that went to the early hours of the morning because they were hitting a deadline and they didn't have any time left. And so whether they were doing something, that was suspicious or not, it was irrelevant. I mean, they just ran out of time.
Mm.
So I think having adequate noticing, giving the public time to react, that is how you are inclusive, and requiring the outreach.
Mhm.
I'm not sure we need to, I'm noting that it's a question here and that there were some recommendations from the task force around meeting times and when they happened and, and things like, I'm not sure that's appropriate for us to weigh in on. It's just,
Right.
that's kind of in the weeds, and that a commission should think of if they are consulting with the community on when works. I have my own questions about whether starting something in the morning would actually engage more people, but I understand wanting to end before midnight and, so I don't know. I don't know that we should be weighing in on that level of detail.
I agree.
I don't think so. I think that's something for them to decide. I mean, I know when we did public input hearings, we tried to make them on weekends and in the evenings, because we assume most people worked. And so we would try to vary them so that there were some choices, like if you can't come in the evening, maybe you could come on a weekend.
So like, I would think that our recommendation should be engage with the community to find out the best time for the community.
Exactly.
Right.
That's it.
Mhm.
So, yeah, I think that's something you leave to the discretion of the body.
Mhm.
You choose good people and you you hire critical thinkers, like you said, and you have them make a decision with community input.
Mhm. Anything else on this one? Did we cover?
Why don't you go to the chart and just see if there's
Sure.
anything else there?
It might take a while to load.
Or maybe it just takes a couple clicks.
Well, then it'd probably take you to the next slide. Just maybe if we stare at it like a watched pot.
I don't know. I think you might have to click it again.
Maybe.
There we
It, okay.
Yeah. So. Yeah, so yeah, the RDTF also talked about robust outreach. I will note that they had real disagreements on the statement of work for the outreach consultant. And this was another situation where they're an independent body, but the consultants were chosen for them. They didn't have any say in the contract. And so then they disagreed with the scope of work. And so this is back to, if this is an independent body, they need their own staff. They need to have some say in choosing the consultants. And, you know, it was very clear a lot of things were outside of their control at the time.
Right. Yeah, there was a lot about that in their report.
Yeah,
Yeah.
no, I mean, yeah, I could totally understand. I think we're ready to go to the next one.
Yeah. Are you sure it's the last one? All right, we'll wait for it to load. While we're waiting for it to show up on the screen, this is the 7th area timing. When should the redistricting process begin prior to the deadline, and when must draft maps be produced? Oh, here we go. Okay, great. So I will first just read a little clip from the city reports report, or the city clerk's report, who says, it would be advisable for the Board of Supervisors to introduce and pass an ordinance establishing the task force at least 6 months to a year before the census results are released in April. The ordinance should include the member structure, appointing authorities, and that they serve at the pleasure of those authorities, seat qualifications, deadline for appointments, attendance requirements, minimum number of meetings, assignment of administrative clerking legal support, language access standards, and outreach directives, including where the funding will be derived for each of these. The earlier establishment of the task force will allow the appointing authorities additional time to make their appointments and for the appointees to arrange their upcoming schedules, since the duties will require a significant portion of their time and energy. This will provide the city attorney's office additional time to brief appointees with the California Ralph M. Brown Act, the Sunshine Ordinance, and in general, the city attorney's good government guide to ensure adherence to rules and best practices. The task force members must be made aware of how much time will be required, and their schedule would need to adapt to the task force's majority. And then the 2 main areas listed here on the slide are seating the task force. When must the task force be seated to enable adequate time to thoughtfully and inclusively do their work? Which we've been discussing. The city decided to form the task force earlier than standard practice. So, and the city clerk recommends to begin even earlier next time. So just to clarify that, because we've said that they got started late. They got started late because the census results were released late. Where they were earlier than standard practice is that once census results come out, then the procedure is the Department of Elections director then says, here's what the areas look like. There is an imbalance or not an imbalance in the districts. And so therefore we should, establish a task force, get one going to do its thing. And so the earlier is that the city decided to seat the redistricting task force before the census results were out and before there was a recommendation from the director of elections. But it was still, as you just said, was late in terms of being able to get any, what they really wanted to done. Because I do think that their intention was to have a really good process that was inclusive. And it's, the circumstances were such that, it's not great. So how might legislation help them, to have a process that I think that they would want based on what we've read and heard. And then the second area is map deadlines. What should the draft map deadlines be to enable adequate time for meaningful public input and collaboration? And should the final map deadline stay the same? All right. We'll wait for the chart to appear.
So we're going to tell Marisa it's not clear that this WebEx is better than the other platform.
Yeah, there we go.
Yeah.
Last week it was slow. Last time it was slow too. I was waiting sometimes for it to appear. So this feels a little slower than last time, but it was also slow last time.
Mm.
So, okay, so here, current San Francisco law, the task force is appointed within 60 days of the Director of Elections report if the districts are not in compliance with the law. We already have talked about what compliance means in terms of size. There are no deadlines for draft maps. There's only a final deadline stipulated of April 15th in the year in which the related election will be conducted. AB 1248 would require that the IRC is established not later than 250 days before the final map deadline. You'll have to do the math. I cannot right now. AB 764, the map should be adopted with a minimum of 204 days before the next regular election after January 1st in the year ending in 2 on a Monday, not a Sunday. So I also wanted to add that state legislation ties the IRC seating deadlines to map deadlines rather than to census data. So it's tied to deadlines. I'm going to say that again.
Mhm.
The state legislation ties seating deadlines to map deadlines, not to census deadline, data deadlines. Just to say that. So, and then I already shared with you what San Francisco actually did. The Fair Maps Act says the boundary should be adopted no earlier than August 1st in the years ending in 1 and no later than March in years ending in 2. The Fair Maps report, the Promise Fair Maps report, recommends that we revisit the 2030 redistricting cycle timeline in 28 or 29 and to change the map deadline to land on a Monday and not a Sunday. I have to say I didn't read in detail enough to understand the Monday versus a Sunday thing, but it was in a couple of different spots, although that's all tied together because we know AB 764 is meant to enhance or improve the Fair Maps Act, so I'm sure that that's why those are both the same. But I'm not sure why that's the recommendation, but there's clearly a reason for it. Redistricting task force for San Francisco said that the task force should start as early as the calendar and charter will allow and before receiving census data. And they also suggested recommending, they wanted to be able to prepare themselves informationally and with training. And that's why, and the city clerk made the same recommendation in their report.
Yep.
And I also want to just provide, again, I know I'm quoting a lot from the city clerk's report, but it was pretty comprehensive. So here's another section. Due to the COVID-19 health emergency that complicated the completion of the census, the timeline followed was not the usual practice from years before. In anticipation of the delayed receipt of the census results from the federal government, the city decided to form the task force prior to receiving the census report in order to get the task force informationally ready to begin their duties. Normally, the ordinance that establishes the task force is introduced after the Director of Elections report on the census results and whether the district lines are in compliance. This year, the city decided to forego waiting for that report and move forward with the establishment and appointing of the task force beforehand. The clerk's office recommends that the establishment of the task force and appointments be made even earlier. Additional time to establish the task force would provide more opportunities to review the duties, establish timeline for action, set expectations, and execute those requirements and additional demands. The task force would be able to focus on the actual district lines and duties to accomplish that task by the time the census results are released. So they're ready to do the work once the census results are available.
Right.
The census results are released around April the year prior to the task force's April 15th deadline to adopt a final map. It would be advisable for the Board of Supervisors to introduce and pass an ordinance establishing the task force at least 6 months to a year before the census results are released in April. So if the deadline is April 15th and the census results are a year prior to that, they are recommending that the task force be established 6 months or a year before the census results. So that is a year and a half or 2 years before the deadline, just to help you all with the math.
Yeah.
Okay, the ordinance should include the member structure. Well, I already told you that in a previous, so I'll stop there.
Yeah.
And then the state commission, the 2020 CCRC terms began 1 year before the final map deadline, and their draft map is due on June 15th.
Yeah, I don't remember Dr. Sadroni thanked me for that because we only had 7 months to draw the maps. So we gave them a full year. So I think one thing's clear, it does make sense not to make it census dependent.
Yes.
And it does make sense to go backwards from the final map deadline. And I think the other thing is starting this outreach and recruitment process needs to start even earlier,
Earlier,
right?
absolutely. So
Like in our case, we had 7 months to actually do our job and they took 8 months to select us, just to give you an idea. So clearly it needs to start much, much earlier. So I actually think that 250 days, that's in 1248, is not sufficient for a city the size of San Francisco.
What would you
That's only about
recommend?
8 months.
Yeah, I think it should be at least a year. And that's when they're seated. So that means the outreach and the recruitment and the vetting and all that stuff has happened the year before.
Education.
And yeah. So
Yeah, I like it. I like the year. Sorry, a year.
for seating,
For seating,
yeah.
absolutely.
And then we can get some input on how long for the outreach and vetting. But like I said, 8 months to select us.
Well, I think what's interesting just in the city clerk's report again, just want to note, they said 6 months to a year before census results are released. So they're recommending a year and a half to 2 years before the map deadline.
Yeah.
So it does seem reasonable to require at least a year, but if the city clerk's office, who was managing a lot of this, said 18 months to 2 years, I guess my question would be about that recommendation. Shrinks because people are like, I don't know if I'm going to still be here in 2 years, or I don't know what my life's going to look like. And you might lose people by the time you're drawing draft maps. Like, it's just a question, because anytime you ask people for that
good
kind of a
one.
commitment, is how likely is it that you're definitely going to be using your 2 alternates? Which is why you want your 2 alternates. Obviously, if you're going to have it's even more important if you have a longer period of time, the task force is in place. So that would be my one apprehension about super, super long, although I really like the idea of having more time. Just what's the balance to strike where you start to lose people who are willing to participate for that long?
So I wonder when they said seated, whether because the city clerk was working with our existing process and so was not anticipating any kind of outreach and a long outreach and recruitment process.
Actually, here, let me give you a little clarification. I'm going to just read a part of this again. So they said it would be advisable to introduce and pass an ordinance establishing the task force. So I don't know if they mean establishing the ordinance should be passed 18 months to 2 years, or the ordinance to establish the task force, where the task force is formed 18 months to 2 years. I don't know which one they actually mean.
It's a good question.
It makes sense because it makes sense that it's the ordinance, because the ordinance has to set out the budget and who's doing what, who's on second, right? It fills in all the details that are not appropriate to be in the charter. How much the stipend is and all that other stuff, because they can't take action till after the ordinance is passed. So that makes sense to me, that the ordinance would have to be passed earlier than that.
2 years, and give plenty of time for the recruitment and outreach.
Yeah. Put a plan together, figure out which department's going to do it.
Right.
Well, we said ourselves, the whole reason we're trying to get this done sooner is to give them enough time, because we think
Right, we said that.
we've said it multiple times that You know, like I said, Long Beach said it was a 3-year budget cycle. They had it in 3 different budget years to cover this. So I think seating the commission itself, I think if the CCRC can do the whole state of California in a year, then we have to be able to do San Francisco within a year, right?
I think that's fair.
And then we have to back out an outreach and recruitment process and the vetting and selection piece, right? It's actually outreach and recruitment, then vetting and selection, then they get seated, then they do their maps, and they hit the deadline. So there's actually 3 parts, right?
And so, excuse me, so an ordinance, let's just, 18 months to 2 years with a minimum of the task force being seated a year before.
Yeah, I think that makes sense.
Yeah.
Yeah,
Allow
because
for all
they
those
have to,
bases.
appropriate funds for the outreach and
That
do
makes-
budget augmentations,
I think that makes sense.
right? And we do 2-year budget cycles, so it might have to be earlier for the ordinance even in order to account for that.
Maybe.
Yeah, but anyway, what
We
we're-
don't need to know that.
we
I
don't
can
need to
figure
know that.
out.
That's for them to figure out. But what we're saying is that the commission itself, whatever processes need to happen, the outreach and recruitment, the vetting and selection have to happen in time to give the actual IRC a full year. I think that's reasonable.
Yeah, I mean, I think that as much as we can make it clear that there needs to be a timeline for all of these things and the goal is to give the redistricting task force the opportunity to do their job.
So here's an interesting question. So the FMA requires that the boundaries be adopted by March 1st. And in San Francisco, we stipulate April 15th in our charter. And it was because we had our own charter deadline that we were able to quote unquote miss the state deadline because we had our own deadline. And that's how the redistricting task force was able to negotiate with Director Arns. How much can we miss it by? Right? It became a local negotiation. It was because we have our own charter deadline that is not consistent with the state deadline.
Okay.
So that's, I think, a question. Like, should we have our own deadline or should we abide by the Fair Maps Act deadline? I don't have a strong opinion on that. This one is an earlier deadline. I think what I have a strong opinion on is they need enough time before whatever the deadline is to do their job, to get trained and do their job well.
Right.
But that's a question, I think, is should we, should we align with the state deadline? I like I said, I don't have a strong opinion on it. It's just an open question.
Maybe it's just a question. Maybe it's just a question to share rather than to try to answer. I
Right.
don't know.
Mhm.
I agree. Okay. And I do think that a draft map deadline must be specified. That was what really screwed up this last redistricting task force, is there was no deadline for the draft map, so they didn't do one on time. Then it became too crunched at the end. So
I am not seeing, does it look like only the state commission of all of the things here have a draft map deadline?
I believe
I don't
there is a
see.
draft map deadline for, it's stipulated in one of these state things.
Is it? Maybe I just missed it. I thought I looked pretty closely at all that language, but I might have missed it.
Yeah, so just to give you an idea, the draft map deadline for us was June 15th. Our final deadline was August 15th. So I think having a draft map deadline that's, something like that, 3 months in advance. Because that forces you to draw something, right?
It was 2 months before, June 15th and August 15th?
Yeah, June 15th. Yeah, 2 months, sorry. Yeah,
Really?
so we originally, I think I've shared with you before, we originally thought we could do 2 draft maps. And then we realized after we had all the tomatoes thrown at us, after we had our June 15th one, and we realized we had violated the rank criteria and all that other stuff, we realized we were basically going to have to go back to the drawing board, and we were not going to have time to put out a second draft map and have more tomatoes thrown at us and not have enough time to fix it. And so we actually got really criticized for that, but I think it was absolutely the right decision because we had to really redo things. And the point that I made when I trained all these other IRCs and advisory commissions is get a draft map out early, because until people see what you're thinking about, they're not going to have specific feedback for you.
Right.
They're just going to talk in general and say, keep my community whole. But what does that mean?
Right.
Right?
Could I see that?
Not until they see that you drew a line through their community are they going to come back at you saying, no, you need to move that over 3 blocks. Right? Until they see something concrete, people.
So the earlier it gets out, the
The
better.
earlier the better. And so
Mhm.
I think the big flaw with the city process is there is no interim deadline. There was only a final deadline. And then there was like no recourse if you missed it. So
Did like Long Beach, do they have a draft map deadline to your recollection? And do you remember when it was?
I think it was 2 months before or something like this.
And what about Michigan?
Yeah. I didn't bring all of my written notes, but I have a handy table that compares
Right.
Oh, yes.
Michigan and Long
Yep.
Beach. And I
Yeah.
think
Right.
Yeah.
I put it in there. So
Yeah.
if it was there, I put it in there.
Yeah.
I don't have it handy with me right now, but I did try to compare them on that element. But yeah, I think there needs to be a draft map deadline and
Yeah.
at least
No.
3 months would be better, but at least 2 months before the final, so that,
I think we can recommend 3 months and then let the body decide. But I think
having a draft map deadline.
having a draft map deadline
Is
that,
the request. The recommendation is
request.
have a draft map deadline.
right, and then let the body decide
Mhm.
on
I would say
the timing of that.
at least 2 months before the final map,
Mhm.
but as early as possible,
Mm-hmm.
because that's when you get, I mean, we had like a lot of really nice conversations in our public input hearings that were, prior to census data and prior to our drawing the draft maps. But man, as soon as we had draft maps out, oh my God, we got a flood of comments.
Yeah.
And then we had to go through and sort them and understand them and figure out how to fix it.
Mhm.
And that took a lot of time. And that's why we realized we couldn't do a second draft map.
Mhm.
Well,
Okay.
So. I think
Anything
that-
else on that one?
I think those are the
I
two
think
important things, is that it has to be seated with enough time and they have to come out with draft maps.
mhm.
So yeah, those are the 2 areas.
Yep.
The last thing oh, look how fast that turned.
I saw
Wow.
that.
That
I
was
was like, wow,
Why a slide switch? Wow.
something's happened.
I don't know what's happening. The last slide here is just a bunch of hyperlinks to reports and documents referred to in this deck. I have noticed since then, of course, but had already submitted this deck, so there were some things I wanted to add, like the current redistricting task force report, which, by the way, for members of the public, is very, very easy to find. If you just enter San Francisco Redistricting Task Force in your search bar, it will be the first thing that comes up, and the report is literally at the top of the homepage. So it's very easy to find, but I do regret I did not list this here. And there may be other things that would have been useful, but hopefully this is a good place to find the source information for everything you saw in this deck, you can find in these links. And so I think that was it.
Excellent. Okay, so I feel like we need to summarize the things that we have broad agreement on,
Mhm.
which I think was most of it, really. We have some
Right.
questions. We have some things that might be general recommendations that maybe don't belong in a charter amendment. But on some of the key issues, I feel like we came to pretty good agreement on a lot of these items.
Mhm.
And we probably just need to see it in writing for us to just read it over.
Agreed.
And, agree that that is what we all said.
Mhm.
And then we could actually vote on it and move it forward, but I think we could. I'm not suggesting we meet again before the next Elections Commission meeting, but we can certainly report on what we discussed and, short of having an actual official vote where we believe we had agreement.
Mhm.
So I think what I'm going to suggest is that we try to write up and circulate a document that documents where we believe we have agreement, and then we present that at the next election
At the next election
commission meeting, which
Mhm.
is what, the 19th or 20th?
The 20th.
The 20th.
Mhm.
Because I don't have time to meet again before then. I don't think you guys either.
Yeah.
Um, Does that sound like a good way forward? You have other thoughts?
I have a question. So this, are you saying you're going to write up this?
Well,
Or-
with your assistance,
Okay,
because like I said, we all took notes.
right.
I tried to repeat things, so I think I got where I
Mhm.
thought we came out on, but it may not be completely accurate. So I think we can,
I have a shared document that we add to.
yeah,
Yeah.
and just make sure that we get it right in terms of what we discussed. I
And
need
the
to, I need to start on this anyway because I'm supposed to do the minutes. So
Right. And the deadline for us to look at it, review, add, make comments would be when?
well, President Stone likes to try to post things a week before our meeting.
So
So
next week.
yeah.
Okay.
It may also not be possible to post it
Yeah, I
ahead of
think-
time, so.
Yeah, I think we may not be able to post it, but I want to make sure that, even if we end up having to give a report verbally, that we can summarize quickly so that, we don't all have to redebate things then.
Yeah, I think having, a report that if it's verbal and then follow, I mean, because we can even work on a written report all the way up until the meeting and then it can be posted after the fact as well. To share a summary of the discussion, I think identifying, like you said, where there is general consensus, where there are questions, so that it's pretty easy to track. So people
Right.
don't necessarily have to listen to 6 hours of meetings to hear
Yeah.
all of it, but there is summary points of, here's where we think we are, here's some outstanding questions, and here, this is for you. Again, I don't think we want to necessarily redebate those, but it's not a formal set of recommendations because we won't have had a chance to meet.
Yep.
We
Right.
still have outstanding
Right.
information we need.
Right.
Right.
By then, we'll also know a little bit more with the legislature,
Yep.
which will also be interesting. So, I'm comfortable with us putting together some sort of a report that's like, here's a summary of where our discussions.
Right. Can I just ask clarification, Commissioner Parker, a report to the full body commission?
The full body, yeah.
Okay.
Yeah, and I think, given that what we've read in the news about our legislative sponsors, that they are looking at November, it gives us a little more time to move on this. So we will know at least what the Senate has
Mhm.
done with the two pieces of state legislation by the next Elections Commission meeting.
Mhm.
And then by the following one, we'll know what the governor has done.
Right.
Right. And I think if we can share with the full body at the next meeting, kind of where we are at, because like I said, I think there's a lot of consensus that where the state legislation is going makes a lot of sense for San Francisco. Especially now that they actually are giving us choices for vetting authorities as well.
Mhm.
That the timing might just actually be fine. It'll work out just fine.
Mhm.
And And then we'll be able to take action
Right.
after the next commission's meeting to formally vote on it and if we want to tweak anything. Does that
Okay.
sound like a plan?
Sounds like a plan.
And we may have some questions or input from the commission at the next meeting that might also.
Right.
Inform
Inform
direct
what we're
and
doing
normal
next.
investigation. I agree.
Yeah.
Okay. Any other comments before we open it up for public comment?
No.
All right. Let's open it up for public comment.
Alan Burdell. I'm just going to play something that kind of captures my comments about your presentation tonight.
Getting confused about what you're referring to when you say that. So I guess it's A is the alternative.
May 17th.
Commissioners working on it, and B, can you clarify what you mean by 90-10%? Okay, Commissioner Dye.
Sure. So if you recall, I had already put a summary of all the recommendations we've heard from all the speakers back in November. So that's been posted for a long time. There were still open questions, if you recall, that I had, put in the right-hand column that were questions I had because the recommendations were not specific enough for San Francisco. And I should point out with the exception of the League of Women Voters of San Francisco, all the other ones are state organizations, and they've been looking at legislation like AB 1248 and 764 that could apply to every city in the state of California. And like I said, they're not dealing with things that are specific to San Francisco, like the fact that we have so many supervisors, right? So they have proposed in 1248 a standard commission, what it should look like and how it should behave and what the role should be. And a lot of the general recommendations and best practices are consistent with what we've heard that there's consensus recommendation on. But the parts where we kind of stick out, like the fact that we have so many supervisors, their standard format, and it may not work that well for us. Right. And so that's that's what I mean by the last 10%. That's where I really wanted to get these big brains in a room and have them hash it out make them think about San Francisco and hash it out with us. Because I do think that will take thoughtful discussion. Am very aware.
So I just wonder, are we the big brains? Is that 4 of us here? We're the big brains. Right. And I think you gave a different version of really what's happening here. Okay. You promised one thing to President Stone, but you've delivered something quite different. And it's obvious to everybody and it's disappointing. And I think that Commissioner Stone should look back on this and wonder if you gave her a straight answer, Chair Dye, and I don't think that you did. But thank you.
Thank you, Mr. Burdell, for your comment. Let's see, we have someone on the line.
Hi.
You've been unmuted.
Yeah. Hi, this is Lauren Girardin with the League of Women Voters of San Francisco. Thank you for this great conversation. There's so many things that we feel that you're getting spot on right, and appreciate that there are a few things we're trying to keep looking at and ask some more questions on. These are complicated issues. And as one of the big brains that you brought into one of your earlier meetings to share expert input, I think that you've done a really great process of examining each of these aspects, getting experts to come in and discuss all of these things with you over a year. So I think this is, a well-informed process. One thing I did want to point out is the question of the mapping deadline in the charter. The league feels that there should not be a mapping deadline in the charter, and that San Francisco should use the state's mapping deadline. And there's a very specific reason why. It's because the city attorney during the last redistricting process determined that the remedies in the state law for missing the final mapping deadline don't apply to San Francisco because we have a mapping deadline in our charter. What you can do is look at the memo sent to the redistricting task force on April 19th, on April 19th, 2022. And that addresses this issue on page 1. And so part of the reason things got confusing and delayed and messed up at the end was because no one really knew what would happen if the mapping deadline was missed, because there's just no way for the state regulations to apply to us. So our understanding is if we clear out that mapping deadline from our charter, that will open San Francisco up to being able to use so many more of these great things that are in state law, and that will continue to be improved in state law through redistricting reform. And we will be in touch if we have anything else. We'll go back and listen to the recording, but that was one thing that popped up. So thanks so much.
Thank you so much for that information. That was very helpful. Are there any other public comments? I am not seeing any other hands. So with that, let us close public comment on this item. And we are on to agenda item 5, agenda items for future meetings. So anything else besides what we just discussed, which is hopefully we can look at the package in writing and take a vote on it, or tweak it as needed. Anything else that we would need to put on a future?
I think of everything.
Nothing's coming to mind. I think, again, once we give an update to the full commission later this month, perhaps something will come up that they'll say, hey, obviously we've heard a lot of information at this point, and so maybe we'll be able to answer questions, but if there's something else that they request, maybe that might be. But for now, I think it's just moving again towards recommendations as we capture everything together, get some input, and then, as you said, we'll know more about state legislation kind of soon. So
Very soon.
yeah. So I don't have anything, and I don't know when our next meeting would be. Maybe that's also just.
Well,
I think that probably will be based on the outcome of the election commission, the full body meeting, and the comments that
I think so.
the other commissioners have. So I think at this point, we probably should just wait to see when another meeting would be useful for the public and for us.
yeah, my guess is it would probably be between our next 2 commission meetings.
I will have very limited availability between those 2 meetings. I will be around for some, but I will be gone for a little over 2 weeks and unavailable.
Okay. Yeah. Well,
Yeah.
it's going to depend on our availability for sure.
Yeah.
We
Right.
definitely want you at the meeting to discuss this. So let's see how far we can get. I'll certainly try to provide an update on the state legislation.
Okay.
And as you said, we'll get more input from our fellow commissioners. Great. And let me open that to public comment for item 5. Discussion and possible action regarding items for future agendas. Any public comment? Seeing none, let me close public comment, and we are adjourned at 8:58. Thank
So
you.
exciting.
Thank you all.
That was a good meeting.
It's good. All right.
Again, Commissioner Parker,
I think it's there.
thank you for that amazing report.
Stop recording.